Good afternoon and welcome to ACS's third lesson in the series, What the Constitution Means and How to Interpret It. I'm Rebecca Orrell, Events Chair of the Columbia University ACS chapter. This lesson will cover Equality, the third chapter of Keeping Faith with the Constitution by Goodwin Liu, Pamela S. Carlin, and Christopher H. Schroeder. And now I present Ted Shaw, Professor of Professional Practice and Law at Columbia Law School. Welcome, Professor Shaw.
Thank you. It is my pleasure to be here today with ACS and to talk about equality. What I want to do is talk about some of the overarching themes with respect to constitutional interpretation and equality, and to do that by talking about focusing on the 14th Amendment as it has been applied to race and gender primarily, but also through Section 5 of the 14th Amendment as it has been extended through Congress's statutory embodiments to disabilities, to other protected categories of people who have been benefited by anti-discrimination law. We start, of course, with the observation that the Constitution as it was originally drafted and as it was originally adopted was, as all human endeavors are, an imperfect document. And so we know what those imperfections were. We know what they meant. Perhaps the most glaring of those imperfections had to do with the place of slavery, never explicitly referenced in the original Constitution, but euphemistically referenced in a number of places in the Constitution. It took a civil war to bring about the changes necessary to more perfectly provide for the inclusion of African Americans, of other people of color, and ultimately of women into the Constitution and the protections of that great document. And we still struggle to perfect our union that we call the United States. Brown versus Board of Education, decided in 1954, is a case that almost every American now who is thoughtful and informed would embrace as a matter of correct constitutional interpretation and also as a matter of general principles that our society embraces. The notion that we should not be living in a society that intentionally segregates its citizens according to race for purposes of subordination. And yet Brown was a case that was not decided on principles of originalism. The 39th Congress that adopted the 14th Amendment, contrary to the beliefs of many Americans, was a Congress that engaged in a number of race-conscious measures that it thought was consistent with the 14th Amendment purposes. Those were beneficial to the recently freed slaves. But that Congress did not say anything about school segregation itself. And so when the Supreme Court in 1896, after a long season of constitutional decisions that departed from the purposes of the original framers of the 14th Amendment, and that narrowly interpreted the protections of the 14th Amendment's Equal Protection Clause as they were applied to African Americans. When the Supreme Court, in 1896 decided Plessy versus Ferguson, it did not talk about school segregation as being central to that case. That was a case that arose in the context of segregation of public transportation facilities in Louisiana. But of course, separate but equal was applied to segregated schools throughout the South. And it took until 1954, until the court struck down separate but equal. And in doing so, the Supreme Court ordered re-argument of Brown. Brown was argued twice. The re-argument was for the purpose of allowing the lawyers to further brief the court on the issue of what the 39th Congress intended with respect to school segregation when it enacted the 14th Amendment. If one reads Brown, it's clear that Brown was not a case that was decided based upon a theory of constitutional originalism. In fact, the court made it very clear that in looking back at the question of what the 39th Congress intended with respect to school segregation or desegregation, there was no clear answer. And as a consequence, the court took on the task of deciding the constitutional questions that were posed before it by the lawyers in Brown by using other methodology. As we all know, Brown is well known for its statement that separate but equal education is unconstitutional. The court further said that to separate Negro children from other children of similar age and qualifications solely on the basis of their race may create a feeling of inferiority as to their status in their communities that may affect their hearts and minds in a way unlikely ever to be undone. This was not language that was rooted or rested in originalism. The court looked at the issue of segregation through the eyes of what contemporary standards dictated and struck down Brown versus Board of Education. Brown, of course, led the way to a series of per curiam opinions, many of them, and other opinions by the full court that struck down segregation in many walks of life, whether we were talking about swimming pools or libraries, other public facilities. Brown was, in many ways, the genesis of the legal civil rights movement, the modern legal civil rights movement, and laid the foundation for the changes that we think of that came about as a consequence of a social movement that took place in the 1960s. So originalism didn't allow us to resolve that conflict in Brown, and originalism is not the manner in which the answers to the questions of equality have most often been answered. Now, the court during the 1960s not only dealt with issues of school segregation, but also dealt with race discrimination as applied broadly. We had the 1964 Civil Rights Act that was grounded in the Commerce Clause. One might think that it was grounded in Section 5 of the 14th Amendment, which is the enabling clause that allows grants authority to Congress to pass legislation to enforce the purposes of the 14th Amendment. But in many instances, at least in some instances, some of the major civil rights legislation and some of the major decisions in the 1960s were also rooted in the Commerce Clause. But it was still the 14th Amendment that generated the inspiration for the changes that were brought about, whether or not they technically were rested in the Commerce Clause or whether it was pursuant explicitly to Section 5's 14th Amendment. The Supreme Court also, in the equality sphere, had a long struggle before it began to recognize the rights of women. Women, of course, were some of the most vocal advocates for equality and an end to the system of slavery in the United States prior to the Civil War. And after the adoption of the 14th Amendment, which granted rights to primarily black men, although on the face of the 14th Amendment, the language is all persons, but certainly after the 15th Amendment, in which the right to vote was guaranteed to male citizens, meaning extended to black males in particular, women felt like they had been betrayed, that they had been forgotten. And in a series of decisions after the 14th Amendment was enacted, which paralleled some of the betrayals that were visited upon African Americans as the 14th Amendment was interpreted, first in the slaughterhouse cases and then in the civil rights cases. Women also found that their interests were denied or betrayed. Myra Bradwell, the first woman who had a case that reached the Supreme Court with respect to her admission to practice law in Illinois, had her claims rejected with respect to the privileges and immunities clause of the 14th Amendment. And women were denied the rights to engage in professions in a long series of cases that were paternalistic in their language and denied women's rights to be full citizens. Of course, the right to vote itself, even though the 15th Amendment had been enacted, was not guaranteed to women until 1920, the passage of the 19th Amendment. And even still, the 14th Amendment had little impact for women. When change came, when the 14th Amendment finally had life breathed into it for women, it was not because of originalism. It was because of the pressures of social movements and also some of the decisions that the court began to make as it woke up to the need to depart from the paternalistic stated intention of the court in prior cases which denied women equal rights to men. The court finally began to recognize the 14th Amendment's application. It wasn't until 1971 that the first case was decided by the Supreme Court, which dealt explicitly with the question of the application of the 14th Amendment's Equal Protection Clause when it came to issues of gender. And as we know, we now have a tiered analysis that applies to equal protection cases depending on what classifications are being used, with the strictest classification being employed in race cases and an intermediate standard that is applied in gender cases. The changes that came about during this time were changes that were paralleled by, again, social movements. The ERA, even though it was never ratified by the states, was passed by Congress. Congress had enacted Title VII of the 1964 Civil Rights Act, which included protection against gender discrimination for women. And so we began to see some of these changes take place, both as a consequence of movements, but also as a consequence of a recognition that the law in its contemporary manifestation, and the Constitution in contemporary manifestation, needed to address the inequalities on grounds of gender. And we began to see the extension of protections against discrimination with constitutional dimension, but certainly under statutes that were passed pursuant to Section 5's authority. Section 5, again, the clause that allows Congress to act pursuant to the 14th Amendment's grant of power to protect people from discrimination on other grounds, as I mentioned before, on the grounds of disability. People began to think about discrimination on the grounds of age and on other bases as also being inconsistent with our principles, both as a matter of constitutional law, but certainly as statutory law. These changes were not a consequence of originalism. The sad reality is that originally our Constitution was either silent when it came to protecting all of its citizens, or was non-inclusive. But it was because of the need to deal with the changes in our country as we began to awaken to what was the stated notions of equality in our Constitution more generally, and our deep beliefs in non-discrimination as we came to a better understanding of what that meant, that we began to breathe life into the Constitution and through the Constitution into the statutes that are passed pursuant to authority granted by the Constitution. This is an ongoing endeavor. We're talking about a more perfect union. The Constitution is not dead, it lives. It breathes because we believe that it breathes. Originalism tells us something. It's not that we have an untethered interpretation of the Constitution, but we also know that a lot of the important and most deeply meaningful changes in our constitutional law and as a consequence in our country have come about by looking at temporary needs to have a constitution that enforces our rights as Americans today. Let's stop there and let's take some questions.
Thank you, Professor Shaw. Please send in your questions for the next few minutes, and I will be reading them out. The first question, Justice Scalia told a California legal publication that the Constitution does not prohibit discrimination based on gender. How would you respond to this assertion?
If what Justice Scalia meant was that the Constitution says nothing explicit about gender in it, I wouldn't argue with that assertion, but that still does not get to the question of whether or not the Constitution speaks to protecting women from discrimination based upon their gender, based upon sex. If we look at the language of the 14th Amendment, the 14th Amendment talks about the equal protection of the laws. It talks about privileges of immunity and immunities. The Constitution doesn't mention African Americans in it, or Latinos, or anybody on the basis of race. It talks about equal protection, and equal protection applies to all persons. And so the question is whether or not all persons are protected against discrimination on the basis of who and what they are. And I think it's beyond doubt now that the Constitution provides protection for, particularly for some classifications that the jurisprudence has recognized explicitly, but also that we know framers of the Constitution, including its amendments, intended to protect. And that includes women.
Thank you. If a majority of justices hearing Brown versus Board of Education had applied originalism in the manner Justices Scalia or Thomas say it should be applied, would Plessy v. Ferguson have been overruled?
I think it probably would not have been overruled because the reality is that even though most judges, justices, senators, if you think about the hearings that we have on Supreme Court nominations now, nobody gets up and says that Brown was wrongly decided, and yet we know that there was huge opposition to Brown. And if we look at the decision of the Supreme Court in Plessy versus Ferguson, while it was dishonest in a number of respects, I don't know that I can say that it was entirely inconsistent with the thinking of the original framers of the Constitution. And the question of what would have been in the minds of the framers of the 14th Amendment is one that we were told by the Supreme Court in 1954 in Brown wasn't clearly discernible. So, originalism is important. It is a one basis for looking at what the Constitution, may have meant, but it's not a stopping point. We have to go beyond originalism, and sometimes we don't have answers that are provided in originalism or answers that are sensible for our contemporary interpretations of the Constitution. Sadly, Chief Justice Roberts in the parents-involved decision, along with three other justices, had a view of what the Constitution means in the context of school desegregation, even voluntary school desegregation, which turns Brown versus Board of Education on its head, and in some ways turns us back to a place that is even worse than Plessy versus Ferguson found us, to the extent that it leaves beyond the reach of law and sanctioned by law, at least implicitly, not only racially separate but financially unequal education, and that's characteristic of where we are today in too many of our metropolitan areas.
What do we need to do now in the future to make this a more perfect union? What major issues in this area do you see arising in the next 5 or 10 years?
I have a response to that question, and I'll tell you what really comes to my mind. And this is an interesting time to think about these issues. I believe, it's my own personal belief, that in the 21st century, the most difficult challenges in this country and beyond are going to be on the lines of class. The Constitution doesn't speak to class. There was a professor and a great lawyer, one of the lawyers who was involved in Brown, Charles Black, who wrote a volume and some law review articles some years ago, which tried to place protection against economic status discrimination in the Ninth Amendment. Ninth Amendment has been described as an empty vessel, but that hasn't had a lot of traction. But this is perhaps a significant point, to the extent that I don't think that we can honestly say that the Constitution addresses discrimination on the basis of economic status, and the court said that in San Antonio versus Rodriguez in 1973. And it may be up to American citizens to wrestle with a constitutional amendment. But in the meantime, the question is whether there are going to be any statutory protections that get at these issues. I think the biggest challenges right now that face us also include coming to a point where we can agree on what the parameters are of constitutional interpretation as a nation in a way that serves a society which has changed in many ways. It continues to change demographically and technologically. Those are huge challenges, and in order to do that, I think we have to go beyond originalism. It's just too narrow a lens in which to try to see all of the problems that we're challenged to wrestle with in the 21st century.
Justice Scalia has argued that too often the Supreme Court has ignored the text of the Constitution in order to reach desired conclusions, such as advancing equality protection. How does one counter this type of claim?
Well, Justice Scalia is well known for his textualism. He does not believe in legislative history. I teach a civil procedure class, and in one of his opinions, Justice Scalia made clear that he doesn't believe in even looking at the advisory committee that the court has established, Congress has established, to look into the meaning of what the federal rules said. You just read the rules themselves. Well, that's one argument. That's one way of interpreting a statute or the Constitution. But for all kinds of reasons, I think it's clear that textualism doesn't tell us how to address, some of the issues that we're faced with today. What does it mean to have a Fourth Amendment in the context of technology that allows us to now track a car as it's moving? The Constitution doesn't tell us that. The Constitution doesn't tell us about a lot of the issues, many of the issues in its text itself. I mean, we have to then take the Constitution and try to figure out what it means. And I think the framers originally understood that the Constitution was going to have to be a document that could be flexible and that could be applied to contingencies that they couldn't imagine. So Justice Scalia has one point of view. I for one, am glad that it's not the only point of view or even the prevailing point of view.
What's an effective argument against Chief Justice John Roberts' stance on affirmative action policy?
Well, I've been deeply involved with the affirmative action battles, and I think the core of the deficiencies in Chief Justice Roberts' reasoning is that he equates attempts to subordinate people on the basis of race with attempts to include people on the basis of race. That is to say, he draws no distinction between invidious discrimination and efforts to include people. I think there's no symmetry between those two things. He doesn't draw that distinction, and therefore, if you take his view in the context of voluntary school desegregation, for example, as in Seattle and Louisville, Kentucky, people who engage in efforts to voluntarily integrate schools are just as culpable of invidious discrimination as people who segregated students for purposes of subordinating them. I don't think that's logical. I don't think that it's true as a matter of law, and it certainly is not true as a matter of morality, but here we're focusing on law. So it's too narrow and cramped a point of view, with all due respect, and that leads to a decontextualizing a historical methodology of interpreting the Constitution as it's applied to issues of race and, by extension, to issues of gender.
We have time for one final question. How is the law of equality playing out in the courts today? Is it evolving because of the current composition of the Supreme Court?
The law of equality is always evolving, has been evolving, but unfortunately it doesn't always go in one direction. That is to say, it's not necessarily progressive. There are times in which the court has turned around the progress with respect to our understanding of equality laws. And so what has happened in school desegregation that I just talked about basically is that Brown, while it's a great constitutional case that has had significant impact on the country, is, as I often say, it's hallowed but hollow. And the court, unfortunately, by one vote, and only one vote, in a number of cases, has been deciding equality cases in ways that I think are too restrictive. But there's always going to be other cases. There's always going to be other cases. There's always going to be the need to have folks articulating another vision of what the Constitution means, and you just have to keep fighting. I think this is a court that is at a precarious position, point right now. And we'll have to see what happens in the next few years as the court changes.
Thank you, Professor Shaw. And thank you all for joining today's webinar. Please be sure to tune into the next webinar on October 12th at 3 p.m. Eastern Time. It will feature William Forbath, Professor at University of Texas Law. Good afternoon.
Thank you.